Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Recently, I saw an article about how certain jurors misbehaved, and I thought it would be interesting to talk about how jurors are selected. So let's discuss that down at the beach. So there are people who make probably $500,000 a year acting as jury consultants. And the way they act as jury consultants is they gather a bunch of data and they look for patterns and that sort of thing. And they come in with a series of recommendations about what kind of jurors a plaintiff might want, what kind of jurors a criminal defense attorney might want to see on his jury, and then develop a process to help elicit the answers in voir dire, which is where it's often referred to as jury selection in the media, but the proper name for it is voir dire. And so these are some of the things that the consultants will look at. They'll look at the demographics, the general political environment from which the jury pool is going to be drawn, the particular county. They may go out and get census data from the metropolitan statistical area. They look at the types of industry. People where they're manufacturing, tend to be blue collar. They tend to have a certain kind of attitude, or that kind of attitude predominates. They look at the census data showing education level. They look at the race and ethnic mix of different groups. Again, not to discriminate, but to be informed about what the belief systems may be in that particular area. They look at the poverty level. They take all of that information and they distill it down and they make some recommendations. They tell the criminal defense attorney who his ideal juror is, and they tell him who to avoid. Who are the jurors that should be avoided at all costs? They provide questions for jurors. What kinds of questions might elicit the most interesting and useful information for the consultants as well as the lawyer? And they talk about specific jurors, specific industries, for example, specific religious backgrounds, that sort of thing, where the jurors might be subject to further questioning. Then, in addition to all of that, they do a full criminal and civil background check on all these named potential jurors so that the lawyers have the best information possible with which to determine what jurors to seat and which jurors to avoid. And so I thought it would be interesting to show you what I have done in terms of voir dire in cases that I have tried. And it's a very personal process, but the bottom line is you want to try to get people to open up and tell you things that they might be a little bit shy about telling people in a big courtroom with a bunch of different people present. But that's your job. You're supposed to get them to do that. And so that's what happens. That's what you do. So let's take a look at the voir dire questions right now. So this is a copy of the voir dire that I used in a case involving nursing home negligence. And the nursing home negligence in this case was pretty egregious, but one of the problems that we had in that case was that the defendant was essentially the Sisters of St. Mary. They owned the nursing home. And we didn't believe that they had lived up to their standards. So in order to get a fair jury in a town with a very high Catholic population, you have to do an in-depth interview of your jury panel. And that group of people is called the venire. And you do a voir dire, and what normally happens is the plaintiff goes first. And what the plaintiff is looking for is really two things. One, to sort of introduce the themes in the case, and two, to hopefully pick up on individuals who have negative reactions to themes in the case, even if they don't say anything. Now, when I did this for Dyer, I had somebody in the trial courtroom with me, and their job was to watch the jurors. And we had a list of all of the jurors by juror name, and then each of them had a number. But we would routinely refer to them during voir dire as, Mrs. Smith or Mrs. Jones, because we wanted it to be personal. We wanted to look them in the eye and get their honest answer. And that's a lot easier to do when you say, Mrs. Jones, are you sure you want to do that? As opposed to juror number 9, do you really believe that? It makes it more personal, and it distills it down to something that you can really gauge the response from the individual. So the person who was with me was very good on neuro-linguistic programming. There are certain body language clues that people give off that A, let you know when they're lying, and B, let you know when they are concealing information. There are very few people who can go through a voir dire and remain completely silent, but that was the other thing we were looking for. Because people who remain silent at the end of the voir dire, you have to pick them out and ask them personally why they didn't respond on any of the questions. And you'll see why in just a moment. So the first thing we do is we say, look, we're here today because a healthcare corporation caused the death of Betsy Doe. And those among you will decide whether the corporation's employees committed medical negligence and whether or not that medical negligence caused or contributed to cause the death of Mrs. Doe. We explain the process of voir dire to the panel, and we say, this part of the trial is called the voir dire, which is Latin for to speak the truth, and it's our opportunity on behalf of the parties to select a fair and impartial jury. Now, you'll notice I said parties there. I didn't say plaintiff, because the basis of this is you really do want to get a fair jury. You don't want to have your verdict overturned on appeal because you had a bunch of friends who failed to disclose that they're the next door neighbors of your plaintiffs. So I know you've spent a lot of time wondering if you're going to be called to a courtroom, and you've probably seen dramas on Law and Order and Boston Legal. And the backbone of the civil justice system is fairness. Now, voir dire here is not adversarial. Both parties are working together to get a jury that can be fair and impartial to both sides, and you're going to hear fair and impartial a whole lot. So we let the jurors know that what we're looking for is fairness and impartiality, not somebody who is going to side with one side or the other. Because if you do that, you invite the jurors, or you invite the jury panel, to pick a side at the very beginning of the case. And not only is that not a sound strategy, but because there are often a lot of facts that get left out of voir dire purposefully, you might wind up sending the wrong signal. So that's why we do that. When a case goes to trial, the defense has made a decision that they think they can come out better at trial than by agreeing to pay something up front. Generally speaking, in about 75% of medical malpractice cases, the defendant is right. The plaintiff loses about 75% of malpractice cases that go to trial, which is why good malpractice attorneys tend to have very, very strong cases that they can present up front and get the other side to agree to a settlement. And if they can do that, they make a better deal for their clients. But when things have to go to trial, then the defense knows that they're sort of sitting in the catbird seat. Trials are risky propositions for both sides. You spend a lot of money, you spend a lot of time, and at the end of the day, you come away with a result, and you may wind up having to go and appeal it. So you really want to have as fair a jury as you can possibly have for both sides, because ultimately that's what tends to work out best for both sides. There are 3 times throughout the course of this or any trial that counsel gets to speak to the jury: voir dire, opening statement, closing argument. But other than when you render your verdict as a jury, the only time you get to speak back to the lawyers is during voir dire. So if you're not chosen, it doesn't mean you don't think you're a fair person, because everyone can be fair. However, all of us can't escape the fact that we come to this courtroom with a number of life experiences: where our parents came from, our jobs, where we were born, where we grew up, and a host of other likes and dislikes. Sometimes these things can keep us from being fair in certain situations. For example, I was a respiratory therapist for 13 years before becoming a lawyer. I took care of a lot of trauma victims, and they wouldn't have been there except for the fact that they were hit by a drunken driver. I completely confess that I would not be a fair juror for that type of case. Now, that's not wrong, it's just the way it is, and we just need to know today, rather than after trial, if you can be fair and impartial. So this case involves suing a healthcare corporation. Some of you may be comfortable with that, and 100% impartial, and some of you may not. The purpose again here is to let the jury know that they don't have an obligation to sit on this jury. They have an obligation to tell people how they feel and what their beliefs and biases are, so that we can determine whether or not they are appropriate to sit on this jury. And I think sometimes we because we don't see voir dire during the televised trials, and of course they do that to protect the jurors' privacy rights, because we do not see that, people tend to think that jury selection is somehow mysterious. It's not. It's just lawyers doing a good job of asking questions of people who, like everybody else in that room, are human. Mr. Guerin, who was the opposing counsel, his questions and mine are intended to help you make your own decision about whether this case is right for you. In order to do that, I'm going to ask questions. Mr. Guerin's going to ask questions. Some of them may be personal, but we want to search your background and experiences and answer them as best you can. So after explaining that, we then go down to talking a little bit about the lawyers. Do you know me? You know, most of the time I tell people I grew up all over the world. I lived in Missouri, South Dakota, Iowa, Colorado, and the Philippines. I live in Jefferson City at the time, and I'm a former respiratory therapist, a columnist for the American Association for Respiratory Care, and an author. If you look on Kindle, you can find my books. I have a paralegal who is here to help me, and anything you know about me or Ginger that would prevent you from being fair and impartial. And you usually don't get anything that pops up. We didn't get anything there. So then we go into prior jury service. How many of you have been on a case before? Do you know the difference between a civil jury and a criminal jury? Now, I'm not going to go through all of the voir dire questions that I ask in that trial. I'm going to go through just a few more so you can get a flavor of what we do and how we do it. I think it would be way too long to go through the whole voir dire. It took me almost a half a day, but you have to understand, people are answering questions when I ask them, or they're raising their hands and we talk about the different answers and that sort of thing. So it takes a long time to get through this process. And the reason for that is because we want to ensure that whoever we get on that jury, that we have identified the possibility that they might be biased. And also, it impacts our ability to tailor the answer to certain questions, or the questions that we asked, to some of those preconceived beliefs. For example, if a juror says, well, you know, I would have a lot of trouble with a nurse who had a substance abuse problem. If indeed there is a substance abuse problem in the case, we need to know that, particularly if it's our client, because if they're expressing a problem with substance abuse generally, then that could impact our client. So this is how voir dire is useful for a large number of reasons, not just for sitting the jury, but also for guiding us in the presentation of evidence later on. The burden of proof. We have to prove our case by a preponderance of the evidence, which just means more likely than not. So if using the scales of justice as an example, the scales are equally weighted, the defendant wins. If the scales have one more feather on our side than on the defense's side, we win. And that's how the system works. Now, we have a lot more evidence than that. Our evidence tilts the scales. But if you believe that burden is unfair or too easy, you need to speak up now. So are you going to hold us to a greater certainty than what Missouri law sets forth? Then we go through the order of trial. I tell them about jury selection, about opening statements, about the evidence that gets introduced, and then how the plaintiff gets to go first and last in closing argument. Those of you who watched the Paltrow trial know that the plaintiff there, Sanderson, got to go first and last in closing argument. Those of you who watched the Amber Heard Johnny Depp trial know that Amber Heard got to go first and last in closing argument. There's a reason for that, and that is because the plaintiff has the burden of proof, and so they get the last word. They get the first word and the last word. So we ask, anybody have a problem with that concept? Then we talk about sympathy, and the judge is going to give you an instruction along the lines of, if you sit as a juror, you can't let sympathy rule your decision in this case. We don't want your verdict based on sympathy. So these are all things we tell them in voir dire. Now, jury selection is one of those things that the more you do it, the better you get at it. You have to have a natural feel for talking to people if you're a lawyer. Many lawyers decide they don't want to go into trial practice. And indeed, I wasn't really comfortable with trial practice a whole lot either, but I, forced myself to do what needed to be done for the client's sake. And as a result of that, I would like to think I did a pretty good job for most of my clients. I didn't like the process. It's as close a thing as you can have to, legalized combat. But that's what trials used to be anyway. We used to have trial by combat in the 15th century. I think we've grown a little bit since then, although there are days. Anyway, the whole purpose of selecting a jury is to get a fair jury, and hopefully that's what you wind up with at the end of the day. That's what you're going for. You're going for that fair jury who can give you a good read on the evidence. Juries usually get things right if they are provided with the right evidence. And that's sort of the presumption that appellate courts use. The appellate court is very unlikely to second guess a jury on most things because they're going to believe that armed with the testimony, they got it right. So when an appeal is lodged in a case, you're not complaining about the jury. You're complaining about the judge. You're complaining that he let in evidence he shouldn't have let in, that he made legal rulings that were incorrect, that he didn't admit your expert's testimony, or that he cut parts of your expert testimony that were critical to your case. All of these things are the reasons why jurors have a little bit of an elevated position in the legal system, in that nobody really second guesses the jury unless you can prove that they lied during voir dire. That's called juror misconduct. But even that, the standard is so high, you have to have extrinsic evidence of their failure to be honest. In other words, when somebody says, no, I've never been sued, and then you find 3 or 4 lawsuits that they've been involved in. Now, in Missouri, you can't even raise that after trial. You're given the names before trial. You're expected to do a full civil docket search on everybody in the venire. And if you don't identify somebody who hasn't been fair and honest with respect to their prior lawsuit history, then if you let them on the jury, you've waived that. You've waived that error. And I think that's a good thing to do because it encourages lawyers to do their job, for one thing. And 2, it prevents them from sandbagging, saying, well, I know we got this bad juror, and maybe if we lose, we can file an appeal based on that. Well, they've taken away that ability to sandbag. In Missouri, that used to be, you used to see 6 or 7 of these cases go to the appellate courts every year on juror misconduct, and that's been cut way down since they imposed that rule. So there you have it. There's the science of jury selection and the science of how lawyers handle voir dire. If you found this interesting, helpful, useful, I'd appreciate a thumbs up. And if you haven't already subscribed, now's the time. Anyway, one of the things I always ask folks to do, you're probably sick of hearing me say it, but do try to go out and do something kind for somebody today. It'll make your day. Thanks for watching. Come join me down at the beach tomorrow. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.